public figure Michael Jordan, Madonna. Then there are limited purpose public figures, somebody who's involved in a particular public controversy, and they'll be a public figure for that controversy. If someone has thrust him or herself into the limelight for a specific event, even though otherwise they would be private figures, for example, say somebody chains herself to the entrance of the butcher shop to protest the killing of animals. For that event, she's going to be a public figure. She's injected herself into the limelight. She's sought the public spotlight. She hasn't gained such fame and notoriety that she's a household name, but for that event, she's a public figure. Now, a private figure is someone who can't ordinarily command the attention of the media. You're a private figure, no doubt. I'm a private figure. We haven't voluntarily injected ourselves into the limelight. And you're still a private figure if somebody else tries to inject you into the limelight. There's the case of Hutchinson versus Proxmire. This is a funny case. Proxmire used to give out these awards when he was a senator called Golden Fleece Awards. And they were for people who particularly distinguished themselves for wasting taxpayer dollars. And he said that that's what this particular researcher did, that he got federal money and did a study and wasted thousands and thousands of dollars, the end results of which is to say that if you pester monkeys or bother them, they will grit their teeth and make noise. Now, because he ridiculed his research and said things the researcher said wasn't true, the researcher sued Proxmire. Well, Proxmire wanted to say, well, wait a minute, this guy's a public figure, at least a limited purpose public figure, and so he can only prevail if he shows that I knew what I was saying was wrong or acted in reckless disregard. The court said, no, he's not a public figure. Although he's been put in the limelight, you thrust him there. He didn't voluntarily seek it, and he's not a guy who's so well known he has pervasive fame and notoriety. He writes in specialized journals. He's not generally known by the public. So you have these special rules in libel and slander. The final category is commercial speech. In the area of commercial speech, we're talking about advertising. And in terms of commercial speech is not one of these categories that's completely outside of the First Amendment. It is protected by the First Amendment, but it doesn't have full First Amendment protection. We think commercial speech is hardy, that advertisers will be out there mixing it up and not worry about self-censoring. So it's subject to more regulation, but it gets significant regulation nevertheless. The general rules here are, the government can regulate and prohibit any false, misleading, or deceitful advertising or commercial speech, or any speech that proposes an unlawful transaction. Let's say you want to place your ad to sell cocaine in the newspaper, or the newspaper itself wants to run racially discriminatory ads or gender discriminatory ads. These things can be prohibited under the commercial speech doctrine. So we can get at false, misleading, deceitful advertising, or that which proposes an unlawful transaction. If, however, the government wants to regulate speech beyond these justifications, then the test is far more stringent. There's a three-pronged test that comes out of the Central Hudson Gas and Electric Corporation versus Public Service Commissioner of New York case. The government can only regulate if the speech, again, we're talking about speech that's lawful, not misleading. It can only regulate if the asserted government interest is substantial and if the regulation directly advances that government interest. It's not overbroad. It's very well tailored. For example, recently the court struck down a law that prohibited beer labels to disclose the alcoholic content of the beer, and the Coors Brewing Company challenged the law. The court said, you know, maybe you have a significant government interest in preventing the display of these alcoholic contents because, among other things, it might lead to greater alcoholism, because then, as the state was trying to argue, beer companies might compete for greater content of alcohol on their advertisements. But the law, the court said, was overbroad. It was also significantly ineffectual and under-inclusive. It applied only to labels, not to advertising. It didn't apply to wine or other spirits. It was just beer. So if you're really worried about alcoholism, you've chosen a rather ineffective, perhaps arbitrary, and certainly overbroad way to take care of the problem. Very recently, too, in the 44 Liquor Mark Inc. versus Rhode Island case, just in the 96th term, the court also struck down a Rhode Island law that prohibited all advertising of alcohol prices. Applying the same test, it said, look, if your purpose here is to try to cut down on alcoholism, maybe that's a significant objective to be sure, but the law here is not reasonable. It's not well tailored. There are other things you can do in order to cut down on alcoholism that will make a lot more sense, rather than applying this paternalistic, you can't find out what the price of this product is. For example, the state had available to it the alternatives of education programs. It had available to it other ways to go about trying to keep down or reducing alcohol consumption. This was not a reasonable way. Maybe you could even increase the prices, make it expensive to drink, but this was not a reasonable or very well-tailored way to go about achieving your significant objective. Now, in this area, please be very careful of overbroad laws. That's the thing that will get the government in trouble. A well-tailored law is what you need. If you don't have false, misleading, deceitful speech, and you have regulation of advertising, there has to be a significant reason to regulate, and the law has to be well-tailored.